Yeah.
I go to the early stages.
Yeah, plenty of time for this stuff.
All right, guys, we're going to go ahead and get started. Good morning.
Good morning.
And then you
Have the
just take the
mics
grain and then they do what they do.
Give
with
us
it.
the money.
Well, that's good.
Good morning. Today is October 19th. I'm going to, Michelle Gumbs, I call the Legislative Committee meeting to order. Can I get a roll call, please?
Allen, Bates,
Bates here.
Brown,
Brown here.
Silva,
Silva is here.
Wallace, Gums,
Gumbs, President.
Strathman,
Strathman present.
Pirog,
Here.
Quorum.
Thank you very much. And can I get a motion for approval of the minutes?
Shepro's here. I wasn't called.
Oh, sorry. Thanks, Ken. Motion for approval of the minutes for July 20th, 2022.
Bates moves.
Bates moves.
Silva seconds.
Silva seconds.
I think we could ask for consent.
We
Consensus.
could.
Shep,
Yes.
Mr. Shepro,
If you would like to.
I would like to ask for
Unanimous.
consensus to put to approve the minutes.
Okay, any opposition? None. Very good. Do we have any public comment? I don't have anybody signed up. I don't see anybody out there who has public comment. So under old business, welcome Mr. Dan Shulman. He's going to be doing an update for us, a little presentation. We're glad to have you at legislation for the first time. And whenever you're ready, the floor is yours, sir.
Thank you, Madam Chair and members of the Legislative Committee. I'm glad to be here. I want to introduce my associate, Corinne Bradley. She's a full-time lobbyist in Chicago and Springfield. In Chicago, but in Springfield when they're in session. Also on our team, who's Zooming, is Zach Kautsky, who some of you may know, worked with the county on some redistricting, and he is was not able to be present today, but he is also working on the team. Wanted to give you an update on what's going on in Springfield and politically as it affects Kane County. Right now, we are, 20 days till the election day. And that's November 8th. November 15th is scheduled the veto session, where traditionally the legislature is supposed to consider bills that the governor vetoed. There weren't that many bills that were vetoed. So right now they're trying to debate a bunch of other critical issues, one of which we're going to talk about and the state's attorney is going to talk about. And that is called the fall veto session. Then there is what's called a lame duck session, which is from January 4th to January 9th. That session is generally when they call it the lame duck session because there are a number of legislators that have either retired or are lost their seats, and they vote on very usually controversial issues. One of the issues I predict is coming, and it actually came up last night in the debate, is they're going to try to seek money for the Bears Stadium in Arlington Heights. That's one of the expected issues. So they generally deal with controversial issues during the lame duck session. Then after that, about the 11th of January, the new legislature is sworn in. All 177 seats are up for election this year. This is the only year that happens because it's the redistricting year. So every senator and every House member. So there's going to be significant changes in the legislative makeup of our legislative caucus, and they're all running in new districts, as you know. Then a week after that, there's a gubernatorial inauguration where the governor, whoever wins, is sworn in and serves. So we've been proud to represent Kane County for a couple of months, and we are proud to report some new information that we have been working with Representative Suzanne Ness and with Chair Parag, who's been very adamant about pushing the legislature to release the money for Long Meadow Parkway. Yesterday, Representative Ness indicated that it is in process and is expected soon. When that money gets released, then we can fill out a grant agreement with Department of Commerce, and we'll be able to get the 17.5 million in a few months. What's the next goal? The next goal is get the other 17.5 million. And because of our efforts in Springfield, Madam Chair, our legislative caucus, and that is across the board, we've had help from all of our legislators, but both sides of the aisle, although the leadership has come from Ness, from Holmes, from Castro, that we are going to seek out another $17.5 million this year. The speaker has indicated that he is favorable towards that, the House Speaker. So that is our number one priority. If we can get that, then that would be the full. My understanding is it would handle the most of the needs for the bonded indebtedness. What else is a priority? When it comes to money, protecting the local government distributive fund. Every year, the legislature in the past has watered down the fund. The fund is the money that the local governments receive as their percentage share of income tax. It started at 10%. Now it's about 6.5%. We need to continue to protect that. Kane County receives a significant amount of money. And I don't know the exact amount, but you probably know, Madam Chair. I have to look and see. But anyway, it's very important. And we work in partnership with local governments. I represent a number of local governments and with the fire and police because they depend upon that money also. We're also going to work on a federal earmark for 2023. Earmarks are back, which is sometimes called pork. But pork is, when it comes, our legislators especially support, many of our legislators support local projects because the local congressmen and senators know what the biggest needs are in their state. So we're going to be seeking, that's usually programmatic funding, and there's a little bit on infrastructure too. So Madam Chair and members of the committee, that's going to be about February, March, April. We're going to be submitting those applications. Our other job is to seek to assist the county, the sheriff, the state's attorney, and the coroner with funding for additional capital projects and programmatic funding. There's obviously some needs coming out of the Safety Act, and also there's some needs regarding what the coroner would like to do in terms of additional laboratory efforts, and we're working closely with those offices. Also, my associate Corinne would like to give you an update now on the supposedly most controversial issue out there is the Safety Act. So she's going to give a brief update, and then we can answer some questions, or we can have the state's attorney talk, and then we can answer questions later. So Corinne, why don't you make a brief presentation?
Would you spell your name, please?
Oh, yes, absolutely.
It's-
CORRYN. I know.
And your
Close,
last
but not
name?
the same.
Last name too?
Bradley.
Bradley.
So it's Corinne, not Corrine.
Yeah.
Right.
And I am Corinne and not Corinne.
I'm working on
But-
training people with
but-
that.
As I shared with you before, we both hail from Huntington Beach, California.
All
I
right.
know. Small world.
I think we should go visit, just to double check.
I support a group trip.
I do too.
Perfect. So I know that Jamie will be sharing, or State's Attorney Moser will be sharing the bulk of information about what is happening in the Safety Act negotiations. But so far, we have been working very closely with the legislative sponsors of the bill and State's Attorney Moser to facilitate these large group meetings. And I have been in consistent contact with the House sponsor, Rep. Justin Slaughter. He is considering Kane County to be vital in these negotiations and using the work that we've done as an example, and very strongly considering State's Attorney Moser's suggestions and incorporation for this new bill, or if they do plan on making changes in the veto session or the lame duck session. We also plan on facilitating meetings with both the House and Senate legal staff in order to really have a starting point for what we plan on changing. So Kane County has been a part of all of these negotiations, and they've gone over our budget and are using really the model that we've set in order to move forward.
One more thing I forgot to mention. The other two issues on the agenda coming up over the next couple of months are abortion. There are some legislators that want to strengthen the state's rules on abortion, especially when it comes to out-of-state women and providers, out-of-state providers. There's also some gun proposals out there that we expect to see regarding the Highland Park shooting and assault weapons, but we don't know when that's going to come up. So thank you, Chair Gums. And if you want us to answer questions now or later after the presentation by the state's attorney, we're good for that.
Why don't we hold off on questions until we get the presentations from our state's attorney? Very good. Thank you so much. She'll be right back.
I don't want to tell anybody what to do with their body. Well, it's just, I always have it.
If only Ron could see your PowerPoint.
I know, right? I will forward it to him to make sure he sees this. So I am going to try to keep this as
This is State's Attorney Moser, sorry.
Thank you. I'm going to try to keep this as brief as possible, but I have presented up to 3 hours on this. This act is very nuanced. There is a significant amount of misinformation out there because when you say one thing, but you don't say a portion of it, then you're providing some misinformation. Unless I am completely confused on how to work. Oh, there we go. That was a legal disclaimer. You could ignore. No, don't ignore it. Please don't copy this. So a little bit of background. Now, when we're talking about the Pretrial Fairness Act, the Pretrial Fairness Act is a part of the Safety Act. The Safety Act is safety, accountability, fairness, and equity today. There are 3 different portions of the Safety Act. The first portion went into effect in July of 2021, and there was a trailer bill that was worked on by myself, other prosecutors, law enforcement, advocates of the bill, and the sponsors. And it fixed a lot of what we objected to for that first portion. The second portion went into effect January 1st of 2022. And again, there was a second trailer bill that dealt with that portion. Again, that trailer bill was really designed and created by this partnership that we had created for the first one. And it dealt with some of the issues that we saw within that portion. A lot of that dealt with new laws that were created along with police officer issues. The one that's coming up now is called the Pretrial Fairness Act. And I've listed in here the actual pages within the Safety Act in case you are incredibly bored one night and have the need to read something. It's 307 to 409. There are now 2 trailer bills that have been proposed. Representative Slaughter had proposed one as House Bill 5337, and Senator Bennett recently proposed Senate Bill 4228. Both of these seek to provide clarifying language and to fix some of the issues. The discussions that we're having right now involve kind of melding the 2 of these together and seeing how we can make pretrial fairness work here in Illinois. So what is the purpose of pretrial fairness? It is to eliminate cash bail. Once upon a time, the purpose of our cash bail was to get people to come back to court. Because if you were charged with an offense and you put up $3,000 of your hard-earned money, you would come back to court because you didn't want to lose that money. Because if you didn't come back to court, it would be forfeited and the state would take it. Now, this was great in theory, but in actuality, what it did is it made a disparate system. And it made it so that people who are lower of income stayed in, whereas people who had means got out, and it didn't matter if you were a danger or not. So, Ms. Gums, you and I go out and we commit a retail theft because that's what we obviously do on the weekends. And
Louis Vuitton's.
Louis Vuitton, yeah, that's the only way I can afford that. So with that being said, we go and we commit a retail theft. We get arrested, we go to court, and the court says, Ms. Gums, you have to pay $500 to get out. Ms. Mosser, you have to pay $500 to get out. Ms. Gums has the money, I do not. She gets out of jail, I stay in. I am more likely to plead guilty on that offense because I just need to get out of jail because I have kids at home, I have a job, I have something I have to do. Cash bail does not work. It also doesn't work in the reverse where a dangerous person can pay their way out of jail. We don't want that. Throughout the state of Illinois, there are people who are accused of murder, accused of sex assault, accused of violent crimes who had the money to postpone to get out. This system doesn't work. I am in favor of the elimination of cash bail, but we need to do it to make it a better system so it works here in Illinois. There is a ton of misinformation out there. Both of these things are misinformation that are on the screen right now. More misinformation comes out all the time. And again, a lot of this is either trying to be fear-mongering to scare people into doing something or to give a partial truth and not all of it. What I'm hoping to do today is to give you the real black and white of this law so you can see why there are concerns, but how we're proposing to fix them. The Pretrial Fairness Act created 3 categories of offenders: cite and release, conditions of release, and detainable offenses. We're going to start with cite and release. Cite and release is that if a person commits a traffic offense, a class B or C misdemeanor, which is the lowest of all of our offenses, then instead of arresting the person, the officer will give them a ticket and let them go. There is a great purpose behind this. The great purpose behind this is these are our low offenses that we're not looking to put somebody in jail. It's unlikely that they are a danger in any way. So why are we putting cuffs on them, transporting them to a police department, and then bringing them to court? We've heard from our fantastic public defender, Ms. Conant, that she has seen these long-term consequences in her client of even one night in jail where they lose their job, they lose their housing, they lose their ability to be a productive member of society, and then they just keep coming back into the criminal justice system. So for those issues, and when the person doesn't pose an obvious threat to the community or that they have an obvious medical or mental health issue, they're not being arrested. So there is an issue with all of this because what happens if a person persists in that behavior? What should law enforcement do? Now I'm going to use a complete hypothetical. Let's say Illinois goes through a pandemic of sorts. And as a result, we have to shut down and people are required to wear masks so that we don't spread a horrible disease. All hypothetical, keep this in mind. And what happens if we have meetings and people come to meetings and there are some people who are so anti-mask that they come to that meeting and they start to create a disturbance? Now, we've never seen this happen anywhere. Never happen. Police officers are called. Those police officers say, please desist in this behavior. Here's your citation. What happens if that person continues to do so? They're not a danger to the community and they don't have an obvious medical or mental health issue. What is the police officer to do? In that particular case, and because I've used this pun before and completely intended, the police officers are handcuffed in doing their job and protecting our community. This is language that we are in fact working on with the sponsors, and they understand what do we do in these cases where somebody doesn't do what law enforcement says to do. I believe there is a legislative fix, and I believe our sponsors want to fix this so that law enforcement can do their job. Traffic offenses, they're going to define this. There are several traffic offenses like a DUI, which is a Class A misdemeanor, and add fleeing and eluding, which is a Class 4 felony, which is under the traffic code. Aggravated fleeing and eluding. And eluding. This is where the police try to pull you over and you speed away and you go through stop signs. Don't do this, Miss Bates. But that's add fleeing and eluding. So they're defining what traffic offenses are, and we're working on what to do to fingerprint the individuals who are just given a ticket and released. For those who have been in law enforcement, and Ms. Gumbs, you would know this, a Class B misdemeanor has to be fingerprinted and sent off to the Illinois State Police for it to be on a criminal background check. How are we going to do that? Are we expecting Sheriff Hain to be in court every day when these individuals come in to fingerprint them? Are we sending them back to the police departments? Again, these are things that we know in this experience, but I really do believe that the legislators want to fix what is happening. In addition to this, there is a presumption that people should be released not only for traffic offenses and Class B and C misdemeanors, but other offenses as well. So for example, if you have a Class 4 possession of a controlled substance, when you're possessing a controlled substance, it's likely that you have an addiction issue. That addiction issue is probably a symptom of something more traumatic that has happened. We don't want to give another trauma by throwing them in the jail system. Officers will have the ability to issue these people a summons to bring them into court instead of arresting them. So again, it's creating some really great workarounds for officers so that we can get help for people without necessarily slapping the cuffs on them and putting them in our jail. So with this, again, we're training law enforcement that this is not only for the limited cases, but could be for other cases when you believe that situation warrants it. So that's the first category, cite and release. Yes. Unlawful possession of controlled substance.
What?
Unlawful possession of controlled substance. I speak in acronyms all day. My apologies. The second category of offenders are condition of release cases. The best way to define this is it's anybody who's not a Class B, C, or traffic offense, and anybody who's not detainable. There is no list of these offenses. You just have to figure out if they fit in these other two categories. If not, they fit in these cases. You have probably heard in the news that there are no non-detainables. That is false. There are cases that are non-detainable, and I am going to talk about that in here. Now, what they mean to say is there's not a list out there of cases that can't be detained. But the problem is with the way that they've drafted the law, there are specific cases and some that are concerning that cannot be detained in any way. This is the law of conditions of release. It just talks about timing for both this and detention cases. It says that anybody who is going to be brought to court has to be brought to court without unnecessary delay and before the nearest and most accessible judge. This is not going to be an issue for Kane County because we already run court 7 days a week. The problem is now we're extending court from a morning session to an all-day session, which is why you have seen me here ad nauseum asking for additional funding for myself, the public defender's office, the circuit clerk, the judiciary, and everyone else, because we are having to staff a whole new courtroom. But we already run court 7 days a week. There are many places in Southern Illinois that have court 1 day a week, which means a person, if they have court on Monday and the person commits the offense on Tuesday, they're waiting until the following Monday to even see a judge.
In jail.
In jail. We are talking to the sponsors about this because the intent isn't to keep people in for a long time, but the problem is we have 102 different counties and 102 different counties with resources and state's attorneys. I'm lucky I have 77 brilliant assistant state's attorneys and 76 fantastic support staff who work under me. In some places, there's just the state's attorney, and that's it. And so this is putting a whole new set of duties on them without necessarily giving them the resources to do so. Conditions of release are supposed to be in person, which means that they're being transported from whatever place, whatever city, village throughout King County they're in, and they're being brought to St. Charles. We're trying to work with this to make sure that it's optional, that it's in person, or it could be via Zoom. We've now learned through that hypothetical pandemic that I talked about earlier that we can do court on Zoom, and we can do so while protecting people's rights. We want to continue this, especially for conditions of release cases, because these are people who are not being held. So somebody who's arrested up in Huntley, our northernmost county, you'd have to take them all the way down to St. Charles, and then they'd have to figure out how to get back to Huntley because it can't be the police officers who take them back. So again, this is something that we're working with them on, making Zoom that option. In addition to that, defense counsel has to be given adequate opportunity to talk to their clients. I'm completely in agreement with this. If a defense attorney is going to argue for what conditions should be in place, they should have the opportunity to do so. We're just trying to figure out how that's going to work in each individual county. Yes.
Does that have to be in person or can that be via Zoom as well?
So right now they're saying it has to be in person. You have to give a physical accommodation to make it be in person. We're trying to make it so that it's also a Zoom possibility.
Good.
Any condition of release has to be there to assure the appearance of the person, the safety of the community, and the likelihood of compliance with conditions. So this is going to be arguments by my state's attorneys that a person should be on, for example, a scram bracelet because this is their 4th DUI and clearly alcohol is an issue. That's what we're going to have to argue to make sure that they continue to comply with the law in regards to the cases. The courts can use validated risk assessments when determining conditions of release as well as detention. The big problem we have right now is we do not have these completed and we're set to go January 1st. Between now and January 1st, people need to be trained in how to use this. Again, under Lisa Ost, we have a fantastic court services that have been using other risk assessments and are prepared for doing this. But depending on what they come up with, we are going to have to be ready to go as soon as they have this developed. As a part of this, the court can order electronic monitoring, GPS, or home confinement. The one difficult part about this is that people are given day-for-day credit for this. Home confinement, EHM, or GPS doesn't mean you're sitting in your home 24 hours a day. It means you at least have 2 days freedom of movement. You can go to work, you can go to school, you can go to the grocery store. And I want you to keep this in consideration that there may be people we don't ask to put on EHM or GPS because whatever it is that they're charged with is something they should go to prison for. For example, an aggravated DUI causing a death, a delivery of drugs causing the death of a person, a drug-induced homicide. Those are prison cases. And if you are out while you're waiting for this and you're on GPS and you're getting day-for-day credit, why would you ever resolve that? You'd want to rack up as many days as possible so that your prison time is less. Something we're trying to really work on also. These are some really concerning cases for condition of release. All of these cases are one that the only way I can get them to be held is to prove that they are a flight risk. And I'm going to talk about what a flight risk is defined as when we talk about detainable cases. These are cases that are not considered forcible felonies, and they are all probationable offenses. So something just to keep in mind. So detainable offenses. Now, this is the big one. There are 7 different categories of offenses that can be detained. The first one is that forcible felony that is non-probationable. This is the definition of forcible felony. The ones that have asterisks next to them are probationable. So I cannot argue for those ones that have asterisks next to them to be detained because it's a forcible felony and they are a danger. Robbery, burglary, arson, kidnapping, ag battery causing great bodily harm. These are very concerning cases that the only way I can get them detained is if I show that they are a willful flight. So I have to prove that it's a forcible felony, non-probationable, and I also have to prove that the person poses a specific, real, and present threat to any person or the community. We are working on the language in all of this because a dangerous standard should be a dangerous standard. You're either a danger to a person or the community, and you don't have to put down a specific person. Yes, Mr.
Ms.
Tubby.
Musser, I understand that you have to, all of this has to happen within 24 hours of the arrest.
Yes, I will get to that in a moment or a few moments. It's in there, though.
I just want to understand how you're going to get it done.
I have that same question.
What happened to the flight risk?
I'm getting there. That's category A7.
Sorry.
Trust me, when you read this 24 times, it makes perfect sense.
Yes, Ms. Mosser. With these detainable offenses, isn't it true that the judge can decide if somebody should be detained or not? Don't they have the final word on these?
Yes, for detainable offenses.
Correct.
If I cannot ask for a person to be detained, the judge can't make any decision on them.
But per your example, if someone was involved with a kidnapping, you mentioned with the asterisk is that's not detainable, but you can ask for that person to be detained and the judge can rule on it.
No.
No.
Correct. So I'm going to use kidnapping as an example. Kidnapping is a forcible felony, but it's probationable. I would have to argue that 1, it's kidnapping, and 2, they are a flight risk. And if I can just defer this question for a moment until A7, it'll become more obvious what I'm talking about.
And I would think physical assault would be part of that because you can't kidnap somebody without grabbing them and.
Correct, but that could just be a battery. That's a misdemeanor.
Oh, for goodness sakes.
The second category of offenses is stalking and aggravated stalking cases. What we have to prove is you're charged with stalking or aggravated stalking, and there's a real and present threat to the physical safety of the victim of the offense. And the denial of release is necessary to prevent the threat. Now, there's some concerning language in this because sometimes there's not physical threats in a stalking case. Sometimes it's just stalking. Sometimes it is a person who just thinks, follows the person, shows up wherever they are, puts a GPS device on them. So we need to fix this language. This, along with the domestic violence cases, are the reason why a lot of advocates for sex assault victims and DV victims are in favor of this, because it does strengthen this. And if you're denied release, you can't pay your way out of there. So these are by far and away the better written portions of this. Category 3 is when you commit a crime that's a family or household member. A family or household member is a very long definition, but if you're dating, married, lived with them, or related to them by blood or marriage, you're a family or household member. We have to prove that the victim is a family or household member and that the defendant was either the subject of an order of protection or has a prior conviction for violating an order of protection or domestic battery, and they pose a real and present threat to the physical safety of any person or persons.
Okay,
Yes.
acronyms, please.
Order of protection is OOP, violation of an order of protection is VOOP, or domestic battery is DB. Category 4 is if you're charged with a domestic battery or aggravated domestic battery and you pose a real and present threat to the physical safety of any person. This by far and away is the best written portion of the Pretrial Fairness Act because it really does make it very specific and protect the victims in these cases. Category 5 is certain sex offenses. And so I'm going to go through this quickly because there are only these sex offenses, but there are a significant amount of them. So I have to prove that they committed one of these sex offenses and that they're a real and present threat to the physical safety of any person or persons. The next section is certain gun offenses. So again, I'm going to go through all the gun offenses because there is a number of them. And then I have to also prove that the person poses a real and present threat to the physical safety of any person or persons. Here's a problem that I have. What happens if I can't prove that they are a specific threat to a person or persons? Because keep in mind, they took out the community standard. I'll give you an example of a case that we just charged. We had a person who left the Illinois Department of Corrections for armed habitual criminal, which means he has a lengthy criminal history and it involves weapons. He should not have any guns. He's not allowed to. Well, he gets out, he goes drinking, he passes out in the lawn of somebody. That person calls the police come over, wake him up. Hey, sir, can we talk to you a second? What's going on? He says, sure. He's like, give me a moment. He walks over to the garbage can, throws his gun out. Who's he a danger to? He wasn't threatening anybody. He's a danger to everybody because he's an armed habitual criminal who found another gun while on parole for going to prison for armed habitual criminal. Under this way, the way it's drafted, I can't ask to detain that person because I don't have a specific person or persons because I'm not allowed to use community anymore. Again, something that we're working with because it's a dangerous standard. Yes.
Jamie, I thought community was involved with all of this to a person and community from what I've read.
No, so community is under forcible felony.
Yes.
And it used to be in a definition, but it was removed in one of the trailer bills.
Yeah,
now
the
they-
trailer bill.
Yes, now they want it to be person or persons with the exception of forcible felony where we can argue community. Me neither, to my phone. Oh my gosh, my watch is very opinionated today. So the community standard used to be in there. It's not in everything. We are working to get that in there. We have provided research as to why community should be considered anytime we're trying to detain a person. Now here's seeker category 7. This is going to answer all of your questions of what we're talking about. Under category 7, it says that if a person has the high likelihood of willful flight with any of these detainable offenses or anything that's not a class 4 felony, so class 3, 2, 1, X, M, we can hold them if I prove willful flight. Here's the problem with the definition of willful flight. It means planning or attempting to intentionally evade prosecution by concealing oneself. Simple past non-appearance in court alone is not evidence of future intent to evade prosecution. This is a very narrow definition. So I'm going to give you an example of what some of my Southern Illinois colleagues are saying because they have a meth issue and they have a lot of people in their towns who deliver meth. Meth is at least a class 3 felony or higher. They live in the community. They don't leave the community. They deliver in the community. What is my argument that they are a high likelihood of willful flight? Now, if at the time they're arresting them, they have a ticket to Bolivia and they say, hey, copper, I'm not coming back for this case at all, then I have an argument to be made, but I don't in every single case. That's the problem with this definition and what we're working on to show that we need to be able to argue that a person is not going to come back to court. In my almost 2 decades of experience, I can tell you that I've had people who, unless they are in jail, they're not going to resolve the case because the moment we let them go, they're gone. They cut the bracelet, they leave the county, they do a lot of things. I want you to keep in mind that there's a county to the east of us, no Bob Berlin, not DuPage County, where sometimes we get a lot of that crime that comes over here, especially the carjacking cases. What happens when they go back to Cook County? How do we get them back here for their case if they are not in our community and we can't argue that they just live in somebody else's county? This is a very difficult definition. In addition to that, if you are a class 4 felony and you are not one of the specific enumerated offenses, I cannot argue for you to be detained at all, which means I can't file a petition and the judge can't hold you. These are just a few of the ones that I think are more concerning. Now, I think I've told everyone this because I was so excited. I was on WGN News last week, and I used the example of unlawful restraint that's non-domestic violence. So Mr. Sanchez, who knew I was going to pick on him for this. Mr. Sanchez and I are friends, but let's say one day I decide I'm not going to let him leave this board meeting by having the longest speech ever. Just kidding. That's not an unlawful restraint, but let's say I don't let him leave. I block the door. The only thing that I'm doing is an unlawful restraint. We don't have a domestic relationship, so it's not under domestic violence. That is a class 4 felony for unlawful restraint. There is no other detainable offense associated with that. I get arrested. I go to court. I cannot, well, I wouldn't ask for myself to be held, but the state's attorney cannot ask for a person who's committed a non-domestic unlawful restraint to be held. Now, the counter argument was given, well, if it's domestic, that's not the fact pattern. The counter argument is always, well, there's some other charge that they'll probably be charged with. That's not necessarily the case. And it's also encouraging people to upcharge or be creative in terms of their charging. That's not what we do as prosecutors. We are ethical and we charge what the facts say they're supposed to be. A threat to a school, that is non-detainable. So a person threatens to bomb the school, bring a gun to the school, non-detainable. Aggravated DUI that causes death or great bodily harm. Or aggravated DUI, I'm sorry, a motor vehicle accident which involves death or great bodily harm. So this is somebody who hits somebody and flees the scene. That's a class 4 felony. I cannot ask to hold that person. And for all of you public officials in this room, threatening a public official is a class 4 felony. I cannot ask to detain that person because of the way this is written. Now, do I believe the sponsors want to fix this? Yes. Did I see their reaction when we mentioned these to say, oh, those should be potentially detainable offenses? Yes. The reason why we have been objecting to this is because of that, because we know how it's written right now. And as lawyers, I like something to be perfect before it goes into effect. But I do believe changes are going to happen. Yes.
So who says what, or what law says these
Microphone.
are non-detainable? Bates, please. Who says, or what law says that those are non-detainable offenses? Is that built, was that created in the Safety Act, or was that already standing?
No, it was an unintended consequence of the way they wrote the Pretrial Fairness Act. Because again, if I only have these 7 categories that I could detain under, all these categories that I mentioned do not fall under any of those 7 categories.
So this is et cetera.
Yes, this is et cetera.
Okay.
Which is again why people say there's no list of non-detainables. That's true, but they created non-detainables by the way that they wrote this.
Okay, thank you.
You're welcome.
Oh, I know that there are many legislators who have law degrees. Were these attorneys who wrote this? And I'm just wondering why they would include that. What was their motivation? Because this goes very far away from racial equity.
Some were attorneys, some were not, some are advocates who work in our community. And a lot of it was trying to deal with the racial disparity we do have. I mean, we have to admit that when we look at our jail and our jail is 30% African-American and our population in Kane is 6%, something's going on.
Yes, of course.
I think they were the best of intentions. I really do. I don't think they intended to leave these out. I just don't think that they necessarily thought about it in the way that I, as the state's attorney, would think about it. I spent a lot of time dissecting this thing over and over again. I spent a lot of time with my brilliant colleagues doing the same thing, and we always come up with something. Every time I read the Safety Act, I find something new that I missed before. It's 764 pages long, and it deals with a multitude of issues. I think this is unintended. I think they want to fix it. I don't think anyone did this on purpose. I hope. I really do.
Madam Chairman.
Ms. Bates.
I hate unintended consequences. They are always unintended and unexpected, unpredicted.
Yes,
And, so let's fix them.
exactly. And they're listening. That's what I have to say. They are listening.
Mhm.
So each procedure is going to be set by every county. Right now, as you know, Kane County is a pilot site, so we've been really actively working towards this. For us, we're training police officers on site and release cases. They're going to be given key dates to appear in courtrooms, and we're working on the fingerprinting issue. The condition of release cases, our sheriff, Ron Hain, has said that when you're bringing over the condition of release people or the detainable people, he's going to hold them for all the smaller departments because there are departments out there who don't have holding cells to hold somebody overnight. Bigger departments will just bring them over in the morning. Between 10 and 12, we'll have these condition of release hearings. And then in the afternoon, we'll have detention hearings and we'll operate 365 days a week. Our chief judge hasn't finalized everything, so this is open to change, but it is his intent to make sure that people have access to the court system as much as possible.
Hold on.
Yes.
Okay. You have 24 hours to get this done.
Mhm.
From when does the clock start on that individual's 24 hours?
So that's a good question. And so there's, again, more nuances in the law. So from the time that a person is arrested, they're supposed to be brought to the court without unnecessary delay. And there's a lot of law behind that, usually not more than 48 hours. But in King County, it's usually they're arrested the next day, they're brought to court. I have to file a petition for detainables. A petition for detainables has to happen immediately after I file the petition. So the way that we're going to do this is when people are brought over, we're evaluating them, the state's attorney's office, and we're saying, these are the ones we're going to ask to be released with conditions. These are the ones we're filing petitions on. So we're doing it the same day. Now, the law does say that you can, in a class X, 1, 2, or 3, either side can ask for 48 hours of a continuance from the time the petition is filed, and 24 hours for a class 4 or misdemeanor offense. So that's where this 24 hours is really coming in. For our purposes, we're doing them all within the same day. The Southern Illinois counties that have court once a week, the unnecessary delay is just when that court comes up the next time. So we're in a much better position than some of my colleagues are. The petitions themselves, we're going to be trying to take care of them the same day, if not within the 24 to 48 hour time period, because one, we have to notify crime victims that they can get a protective order. Again, things that we want to do, but we need to hire advocates to be able to do that. In addition to that, we have to file these petitions. These petitions have to show that it's one of these A1 through A6 offenses or A7. We have to put down who it poses a threat to, and we have to argue that there's not a common condition or combination of conditions that could mitigate the threat so that we should release them versus holding them. In addition to that, I have to tender a lot of discovery, and you've heard me talk about this. You guys know that we have an RFP out there right now for a discovery system that's going to make this a lot easier. Anthony Ortiz within my office is leading that charge. I believe we had 12 people that responded to our RFP with different pricing and what they can do. What we need is a system where we can drop all this discovery and we can press a button and it goes to somebody. The way that we do it now is they send it to us, we download it to only upload it somewhere else to send it to somebody. It is wasting a whole lot of time. So we will be back about the discovery system. The discovery that we have to tender is the defendant's criminal history. We already do that. But now we have to tender any written or recorded statements and the substance of any oral statement made by any person if it's relied upon us by the state. Let's talk about a domestic violence case. A domestic violence case is based on what the victim says happened. It's not that the police officer sees it. It's not that I have a video of the recording. It's that a victim says this occurred. We're all going to have body cameras at some point in the entire state of Illinois. Of those individuals, they may have 2-3 hours per police officer of body camera that I have to turn over. I have to review it. So does the public defender to ethically do their job. It's not like I can fast forward to see, oh, here seems to be 15 minutes of where they're having the conversation. Plus, there could be an officer standing here who captures everything of the incident that happens at another point. So there's a lot that we have to do during this time period. In addition to that, the complaining witness can be compelled to come forward. This is something we're really working on because the complaining witness, which is usually the victim of the case, should only be compelled to come forward if it has something to do with the detention. We should not be holding many trials where we're essentially putting up a victim of a DV, a rape, of another violent offense, and they're being questioned about what just happened 24 to 48 hours before what happened. Again, language that we're working on with them. It also can be considered a quasi-suppression hearing, which means if the defendant says that somehow we obtained the evidence illegally, we have to be able to argue that no, we obtained the evidence legally. This could mean that we have to call police officers to either come in and testify, or we just have to call them to get information and do it by proffer. There is a lot of things that are going on now in this day-long hearings that we're having in regards to these cases.
What's CW?
Complaining witness.
Of course. Why didn't I?
That's okay. There is a television network called the CW, so
Glossary.
it's fair enough. In addition to that, now, taking away detainables. Now, there is a new requirement that if you fail to appear in court, instead of a judge issuing a warrant for your arrest, we have to issue a summons and something called a rule to show cause. This has to be given to our sheriff, and our sheriff has to serve this on the person at least 48 hours before the next court date. If we don't serve them, we have to try again. This alone will delay justice. Now, I want you to think of a person who maybe just lives in Southern Illinois. How are we serving that person? Are we sending this notice down to Southern Illinois? It doesn't go into our law enforcement database like a warrant does. So if you're pulled over in DuPage County, but we're trying to serve you in King County with something, DuPage County is not going to know. Our St. Charles Police Department wouldn't know what the sheriff's office is doing. This is something that I do believe that the sponsors are moving on. In one of our conversations, they did talk about this specifically to give the option with the hope that we use rules to show cause as well. Now, I understand why they're doing this. There are people legitimately who have missed court because they lack the transportation to come to court. They didn't have the funds. Something happened with their kids, or they had to work and they were going to get fired. I want you to think about the person who has court for a year and they have to come back every month to come to court. How much vacation time do each of you have in court or in court in your jobs? Is it 2 weeks? How do you miss all of that in terms of going to court? I understand why they want to do this. It's just there are some people who just will never come back to court, and we need to be able to issue warrants. Our judges are great at giving people an opportunity, especially in communication with their defense attorneys, give them a few days to call their client to get them to come back to court. We really are not just trying to arrest everybody because that's our goal. Our goal is to keep people out of the criminal justice system, but we also have to go forward with cases because that's justice. Yes.
Couldn't that certain cases, the ones that are coming back every month, couldn't that happen via Zoom?
Yes, and that's what we're doing. And that's our rate of failures to appear, or FTAs, Miss Bates, for all my acronyms, have plummeted because we have Zoom court and we've made court more accessible. We just need to keep doing this. So here's the last big issue I want to talk about: prospective or retroactive. The law right now is silent. Does this law only apply to the people who are arrested at 12 o'clock on January 1st on, or does this apply to everybody in our court system? I have talked to almost all of our state's attorneys, and it's all over the place as to whether or not the state's attorney is going to consider it prospective or retroactive. I have taken the position that it's prospective only, so that everybody who is in our jail between now and December 31st at 11:59 are going to be under the laws that we have now. I've done that because we've done research into this, and when it's silent on the law, you should assume that it doesn't apply retroactively. In addition to that, all the people who've gone through the court system now have had due process. They've gone before judges. The information has been put out there. Probable cause has been found. There's no reason to undo that because of a law that's being made for January 1st. Not all counties are doing that, and I have a really big problem with that because now you have different justice in different counties. And it's not that they're wrong in other counties, because they're just interpreting it a different way. We should never have to interpret laws. This is something that I do think that they are going to deal with in the trailer bill, because this is something that needs to be applied throughout the entire state of Illinois in the same way. So what's going on? 100 out of 100 of the 2 states' attorneys have objected to the Pretrial Fairness Act. We have not objected to it because we don't like what the mission is. We like criminal justice reform. We want criminal justice reform. We want to eliminate cash bail. The problem is, because of what I've just detailed over these last, I assume it's just 5 minutes that I've been speaking, there's many very big problems and many unintended consequences. Some of the state's attorneys have engaged in lawsuits. And if you're ever interested in finding out what those lawsuits are, I can tell you what they are, but they're constitutional issues. And one of those big constitutional issues is the elimination of cash bail. Cash bail is in our Constitution, the Illinois one as well as the United States one. You have a right to bail by sureties. And these are concerns that we have as we're going through this. Other of us, and this I have not updated because there's 4 state's attorneys on there now, have been asked to be a part of the negotiating team. That is myself, DuPage County, Champaign County, and Peoria County. And what we're doing is we're talking to them about these issues that I've raised to you, along with other issues that are kind of nuanced throughout the entirety of this law. The 100 of us are lockstep in the way that we're proceeding. We want this fixed by legislation, but if it's not fixed by legislation, then there is the litigation portion of it. But we want to do what's right for our community, because I want everyone to keep in mind that defendants are my community as well. They are the people that I look to protect their rights and to get them out of the criminal justice system. But I also have to balance that with protecting victims and protecting our community, because when people commit crimes, there is a consequence for that. So with that being said, I am open for questions. We do have our lobbyists here who can also help with the questions.
State's Attorney Moster, I just have a couple of questions. This all makes total sense to me because I've lived in this world my entire life. So when we speak about things, and originally, and I've said before that I read this bill many times as well, and I didn't want folks to vote for this because there were so many things that needed to be addressed, as we have all been explained here today. I did have a question about a couple of things on my radar. Not being handcuffed thing. When we talk about that, you talked about the police officers feeling like they don't have the ability to do their jobs. Speaking with them, trying to kind of quell some of the misinformation, and officers saying, well, I can't be a cop anymore. I can't do this anymore. Some of my argument is we, in fact, my entire life have done something called street adjusting. So when we talk about pre-arrest diversion, that means street adjustment is we don't lock everybody up. We used to do that, and we've kind of not done that, but we're coming back to that. So when we're training our officers, I hope that we remind them that that's something that we're trying to get back to, is the street adjustment. Some folks will remember that, some won't.
Absolutely.
And then also, when we're issuing the summons as opposed to a warrant, I used to enter those suckers like crazy. My concern is, and I guess I wasn't aware of this, is there an argument that we can make to have that entered into leads or our law enforcement database so that we don't have to physically send one of our deputies south? Because so when you enter a warrant, I can see it here in Kane County and I can see it in Nevada. It's all in the computer system, but you're saying that a summons would not be available to anybody else, which is obviously very problematic.
Right. And what gets entered into leads is dictated by the Illinois State Police. So that would have to be a change both legislatively, which is not dealt with in here, but also through the Illinois State Police. Could you imagine how many thousands upon thousands of rules or summons that would be entered in there? It would just bog down the system.
That's fair. Yeah.
So I don't know that that's even feasible as an opportunity.
Fair. I mean, yeah, I understand that. So. Mr. Tepe, go ahead.
Thank you, Madam Chair. Ms. Mosser, you're one of the three on a committee to do this.
4 now.
Okay, one of 4.
Mr.
What's the
Tepe, can
timetable?
you
How-
get into your mic a little more? Sorry.
You're one of the 4 now on the committee to do this. What's the timetable? What's the probability of getting something done before the first of the year and having it be distributed so that people can understand it?
That's a good question. We are hoping, as Mr. Showman had said before, that we could do this in the veto session, which is in mid-November. If we get it in mid-November, it can be voted on. They need a supermajority. I'm learning all legislative things. They need a supermajority, and then it has to go through both the Senate and the House, and then it has to be signed by the governor. It could be changed. Here's one of the concerning things. Let's say we change this in November and it's great. It's everything that we want. When do we train people on it? We also have to redo our forms, our procedures, everything. So we're also asking for an extension of this. I don't know if you have anything additional.
Yeah, Mr. Shulman.
The concern is that the veto session is scheduled to last 6 days, November 15, 16, 17, and then off Thanksgiving week, November 29, 30, and December 1. And they're talking about shortening it to 1 week. So it may get pushed into the lame duck session, which technically means that the law will have already taken effect. Now, I'll be honest, laws take effect, but then the agencies have to issue rulemaking to implement those laws. That has not been finished. So we're just in a gray area now in terms of enforcement. So my guess is that they will not be if they're planning to take it up in the first week in January during the lame duck session, there will be some indication that they are not enforcing it. Until they indicate they're enforcing it, we're in a gray area.
That's a,
The chances of a fix, some kind of fix are good.
question is
And the
when.
important part is Kane County's at the table because of the work of State's Attorney Moser. She's been very diligent and many other members of the sheriff and others. So we are at the table. And I will say this, for the counties that sued, that's all well and good, but they're not at the table really, because they don't have a say because they're seen as, and one of the issues here is the sensitive issue is that this is a bill that has been worked on for years by the Black Caucus, and they personally, if certain states' attorneys decided to sue, that didn't help them at the negotiating table.
Ms. Braley, I think you had a.
One of the things I wanted to add to that is something that State's Attorney Moser had stressed to me and that I've been stressing to the sponsors is, if anything, a delay. So if changes do need to be made and they won't get to them in time for veto session or through lame duck, in terms of the timeline, a delay is one of the things that we've asked for up front, first and foremost, before everything. And State's Attorney Mercer has been vital in showing why we would need a delay even prior to making any of the changes to the act itself. So that's something that we've had multiple meetings on. Every time I talk to the sponsors, I've asked about it. That's the one thing that they're pushing for up front, is that delay in start time so we can make that happen and make things happen. And Kane County already has some of these things implemented in what they do, which is why State's Attorney Moser asking for that delay is so vital. Because if we're not ready, how are other counties expected to be ready? And that's the argument that's being made to the governor right now.
Very good. Madam Chair, go ahead.
How long are you thinking of the delay? Because we've got, the governor's going to be inauguration on the 18th, January 11th. The new legislature is seated. When are we looking? February, March, April?
Good question. If I could predict what the legislature would do, then I would be the owner of DraftKings.
Yeah.
No, there's no, to be honest.
What do the state's attorneys want?
No, to be honest, Madam Chair, I think any delay would work, right? But it's a 6 months,
That makes sense.
6 months, but it really is going to be a decision that they make at the last minute. But I'm not sure, we just don't know.
Is that something that ISACO and this legislative committee can help support?
Of course.
A delay in implementation.
Yes.
I'm not sure that would help us now because we're trying to, I don't know, it's up to you. I think the county board is welcome to take a position and weigh in on something like that.
And I think that's neutral. We just want to make sure that everyone feels comfortable.
The legislative committee has the right to make a decision on any issue.
And I'll let our state's attorney advise us on that.
So I would recommend yes. And the reason why is I want the elimination of cash bail to be successful. And if we're rushing everything and having to change everything that for months we've been working on, our likelihood of success is not going to be great. And so we want this to work. And from my position, again, because we're still looking at funding and we have to hire people, and we've brought up the issue of both of these things. If we have a delay in the training, redoing our policies and procedure, being able to find the funding, hiring really good people and getting them ready, we will be like New Jersey, who had a successful elimination of their cash bail system.
Ms. Braley, go ahead.
Yeah, of course.
One of the biggest arguments for the delay was the funding. So something that we had discussed in our initial meeting with the sponsor, Representative Slaughter, was the lack of access to funding and looking at where it was coming from. And State's Attorney Moser made a lot of helpful suggestions in terms of where they could find the money from. But we provided the legislative committee that is working on this with our budget to show what it would look like for the next year, for the next 3 years, what hiring looks like, what expansion of court services look like, and
King
where that
counties.
money would be coming from. And so that is something that they're strongly considering because of where Kane County is, and then looking at smaller counties across Illinois and where they'd be finding that money from. So if a delay goes into effect, funding will be probably the main driver of that.
Very good. So I get, what I'm gathering right now is this legislative committee body should, in my opinion, take a position that we support the delay.
The delay.
I believe that your presentation was amazing, very essential, and a lot of folks, when they come to me, the misinformation is crazy. You're excellent at explaining it all, so I really, really appreciate you being here. But I feel like at the county board level, we should take a position to support this delay.
I would concur. And I think because of our own election cycle, we should be doing it in November with this seated board and not the new board. And if I can request that we ask for the advice of our lobbyist as well as our state's attorney in drafting that letter so that we can review it and have buy-in from some of our astute board members on the language, then willing to sign it. And then I would like to have it passed, to make sure it's passed in November by resolution that we do support this. So that there's no question that it is not full board support.
Agreed. Do I have any opposition from any of our legislative committee board members or any comment?
So that's fine.
Mr. Shepro, go ahead.
Well, I had two questions, I guess. Long time ago, that is to say at the beginning of the presentation, I think one of the presenters said something like that they were looking at Kane County as an example of it sounded like where we've got funding in place, or words to that effect. And I wondered about that because that we still haven't adopted a budget, and I'm guessing that other counties of similar size are in a similar situation. So I wondered what it was that we've done that the legislators viewed as an exemplar.
So we're the pilot site. That's why they're looking at us in the way that they are, because we have been working on the development and implementation. So when we say there's a concern, it's a concern that's based on our procedures that we're putting in place. So that's why they're looking at us as a model, because we're a pilot site, not because of funding. I have explained to them our funding issues that they have here. But when I say, hey, I need 3 assistant state's attorneys to staff this new courtroom, I can say, because this is the procedure that we put in place. These are the back and forth that we had to figure out what works and what doesn't work. This is why we developed this as the proper working courtroom. That's why. We're not talking in the hypothetical anymore. We're talking about the procedure we're going to put in place.
But not necessarily whether we are going to have the money to do it.
Correct.
I
And then
believe
I
that,
just had-
I believe that was brought up with the delay argument is that there's a funding issue, I think, so.
Not just for Kane, for everybody.
Correct.
Well, although it seems to me that the argument for a delay is not just funding. As Mr. Schulman pointed out, the rulemaking procedure does not seem far enough advanced to be ready on day one. I mean, there's always, I guess, ways to bypass the rules, but has anybody seen drafts of the proposed rules?
So we should include that as what you're suggesting.
Well, I
I
would strongly support a 6-month delay in implementation or effective date. But I guess my question would be, not necessarily of the whole act, some of which has been pointed out, has already gotten into effect. So am I right in assuming that the delay request would be limited to the Pretrial Fairness Act?
That's correct.
And then I just had one question about the example that the state's attorney gave about the masks. And I think it was something like, you know, there's a rule about masks, people violate it, they come to the meeting and cause a disruption, and they're not eligible for detention because they're not a danger to the community. And I guess my question would be, isn't the reason for the mask mandate is that people who don't wear masks are a danger to the community? So I guess that would seem to me, if anything, to be a more compelling reason to say, you know, kind of like Typhoid Mary. I know that the whole mask issue has been very controversial, but if the underlying premise of those kinds of rules are protecting the community, it would seem to me that a judge could very well find, and maybe should find, that people who are unwilling to comply with health directives are a danger to the community. The same as if you had a quarantine for some other disease.
So, Mr. Shepro, what the Pretrial Fairness Act did is actually took away the discretion of judges on certain cases. In the
Mhm.
example that I gave, what that individual would be doing is a disorderly conduct. The disorderly conduct is a
Okay.
Class C misdemeanor. A Class C misdemeanor is one in which only a citation can be issued, no arrest.
Okay.
Now, could an officer in a police report say that he believes that an unmasked person in that particular situation is now a medical threat to individuals? Potentially. But the problem is it leaves a lot up to question. And
Okay.
it also continues or allows the continued behavior by giving a citation instead of removing the person from a situation.
I guess
Another-
I guess I was confused because maybe because in your example, it wasn't that they weren't a danger to the community, it's that the legislature has removed that offense of disorderly conduct from judicial discretion.
Correct. And being an arrestable offense.
Okay. I guess okay, well, that answers my question. Thank you.
Thank you.
Madam Chair, Bates, please.
Yes,
Oh, no.
Ms. Bates.
Can't get away from
I
it.
believe that was Mr. Shepro brought up a good point, which was that because
Oh,
many
nothing
parts
like
of the
a
bill seem
Good
to be
roll.
executable and carefully thought out and not in need of change, that we should not delay parts of it. And I'm thinking that you have listed 7 cases where it sounds like those are well defined. It's the et cetera cases that are causing the problems, and maybe those can be delayed and not the other ones.
There's really no way to parse it out because all of these are interwoven together. So there would be no way to allow some to go in and others not to. In addition to that, we still need the funding, which we don't have. We still need to adjust our forms depending on what happens, and we need to adjust our procedure. And then the legislature has to do the rules portion of it. So all of that is hand in hand. We would ask for a delay of all of it.
How are you gonna find it?
But when you say all of it, you mean the Fairness Act and not the so overarching Safety Act.
Correct. Just the Pretrial Fairness Act.
There's a difference in lawyers too.
Very good. Does anybody else have any questions or comments?
Just a comment about the timeline.
Yeah, Mr. Shepro, go right ahead.
It seems to me that the timeline, both that's been discussed here and what would appear to be the case in Springfield, is that I think this committee should take action if we can do so today, even if it's only by consensus, to make sure that this gets forwarded on to the next level. Although I did hear, I think, Mr. Schulman note that this committee might have the authority to instruct on behalf of the county. I think, Madam Chair, your comments were correct that this ought to have the imprimatur of the entire county board.
That I would prefer that. I think that buy-in would be very appropriate. And we have a board meeting that's going to be scheduled on November 7th, which I think would be very appropriate. The next one, that'll be on the 22nd. So, but since we're going into veto session on the 15th, I think the 7th would be most appropriate.
By the 7th, we may know more information. And if it turns out that there is some action that's being taken, might not require the need for that resolution.
Okay,
If
perfect.
you want me to give another report on the 7th, we can do that, or the state's attorney can.
That would be,
Yes, yes.
yeah, that'd be fantastic. So why don't we go through the exercise of having you draft the letter that Dan and Jamie draft a letter so that we can take a look at it and go through our own drafting and then get it ready to move forward for the 7th.
Could it be ready for executive committee on, is that the 1st?
It depends on how, yeah, that'd be fine, but to review, absolutely. But the board meeting is going to be on the 7th. If so, we have to wait till we get the full board, but absolutely.
Great.
Okay.
Mr. Schulman is going to take the brunt of the work. Thank you.
Thank you, Dan. Okay, perfect.
Thank you. All right, very good. Nobody else?
Madam
has it?
Chair, Strathman here.
Yes, Ms. Strathman.
I just want to thank Ms. Mosser for such an excellent presentation. That was very informative and answered a lot of my questions. Thank you very much.
Thank you.
Absolutely, Madam Chair.
Excuse me. I would like to also request after the election with the current board members and the potential new board members that we have a committee of the whole where all are invited so that this can be once again presented with updates so that the seated board members and the board members who are yet to be seated will all have a full understanding of what we're facing.
Absolutely.
That'd be lovely. Thank you.
Excellent. Very good. I also want to thank everybody for coming. It was great to hear you. I know people are interested in all of this stuff. Great work from our lobbyist team. I appreciate you, and Ms. Mosser, I know appreciates you as well. So if we don't have anything else, we have no reason for executive session, and I would take a motion for adjournment.
Pepe?
Nobody wants to leave?
Not on the committee.
Mr. Guest?
Anybody want to make a motion to
Oh,
adjourn?
Shepro will move.
Shepro and Strathman seconds. All right, all in favor?
Wouldn't that be something, Jamie, if you let fellows here?
All right, very good. All in favor, aye?
Aye.
Thanks, guys.